All right, good afternoon. My name is Chris Brown-Haugen, and I want to welcome you all to day 2 of our Restorative Justice and Diversionary Model Training. This isn't clicking to the next one. So pause 1 second. Perfect. At this point, our hope is that you have either participated in day 1 of the training or you went ahead and watched the video that we sent out earlier this week. Today is really going to build off of day 1. So day 1 was sort of the more theoretical overview of restorative justice and why we use it. And today is going to be really more of a practical focus, how to actually implement restorative justice into diversionary programs. As a reminder, there is the workbook that we had from day 1. The second half of that workbook actually follows through day 2's training. So if you have that accessible, go ahead and pull it out. If you need us to resend it, you can throw that in the chat and we will resend that to you, but you might want to follow along with that. We also sent out an implementation guide earlier today, and that's just another sort of resource for you all to take with you. It really is sort of a framework of questions, things that you want to think through if you are either starting or expanding or continuing to operate a restorative justice program. So from day 1, some of the takeaways we hope that you left with: an understanding of the restorative justice principles, values, and practices. We also hope you had an understanding of the many reasons why Liz and I are advocating for the increased use of restorative justice within the criminal legal system and specifically within diversion. Also, some of the issues to be aware of when you are integrating restorative justice into a diversionary type program.
So last time in part 1, Chris and I introduced ourselves and our personal and professional backgrounds. And today we wanted to give you a little bit more background about the Restorative Justice Council and the origins of this project. So in 2017, the RJ Council shifted its focus to cultivating system level change and to encouraging greater use of restorative justice within the criminal legal system. The goal was to create a partnership between prosecutors, defense attorneys, and the RJ Council to increase awareness and education around restorative justice practices. After many conversations and meetings, a district attorney and public defender team was created to take on these tasks. Chris and I represent that team, and we are so very grateful to all the amazing experts that we have on our advisory group who constantly guide us in our decision-making and how we really implement what our goals are. So this presentation is one of those ways that we hope to encourage greater use of restorative justice within Colorado's criminal legal system.
All right, so in terms of a roadmap of today's presentation, we're going to start by talking about creating a safe space for restorative justice. We will go over some best practices, including victims, system side, and program. We'll talk about creating buy-in with stakeholders and system actors. And then the most exciting part of today's presentation is the last 45 minutes is going to be a panel where you'll be able to hear from 5 different experts in restorative justice who run restorative justice programs in diversionary models across the state. So that'll be a really good opportunity just to hear about how some of these things are working in practice. So the first thing we want to talk about is access to restorative justice and eligibility. And we did touch on a lot of this in day 1, but because it's sort of foundational to implementing a program, we wanted to just revisit it briefly at the beginning of today. So as a reminder, there are some statutory disqualifications for restorative justice, and that is within court-ordered restorative justice programs, as well as state-funded diversion programs. Those disqualifications center around domestic violence cases, as well as sex offense cases, and you can refer to day 1's materials for some more details on that. At the base, what we need for basic eligibility is a defendant has to be willing to take accountability and work on repairing the harm. And that sort of, makes sense. It wouldn't work. You can't restore harm if someone's not willing to take accountability for what happened. So at its core, that has to be in place for any program. Beyond that, we wanted to talk a little bit about victim requirements. So there are some programs, including the one that I run, that do have requirements that a victim be open to restorative justice in order for a case to be eligible. And I'll talk later more about my program, but what we wanted to talk about today is we're actually advocating not to have any of those requirements. In order to ensure equity, we would really advocate that restorative justice should be available even if victim objects. And this is just to ensure that all eligible defendants get an equitable opportunity to participate in restorative justice. One of the most common questions that we got on the registration form was, how do you identify which cases are appropriate for restorative justice? How do we know what cases to send through? And I wish this was just a real easy question, but the truth is that everyone sees this a little bit differently. There are some people who think all cases are appropriate for restorative justice. There are some that think only cases with a victim are appropriate for restorative justice. And there are some that think that there's very specific criteria that needs to be in place in order for a case to go through restorative justice. And again, you'll hear on the panel from people and their different views on this. But what we would like to propose is a suitability framework, a way of thinking, some questions that can get you thinking if you're trying to determine which cases are appropriate for your program, a way to think about that. So some of those questions include, was someone harmed? And harmed can be defined as physical harm, emotional harm, mental harm, financial harm, however you want to define harm. But was there someone who was harmed in a case? Is the victim asking questions or wanting to talk with the defendant? Is the defendant wanting to apologize or talk with the victim? And are the defendant and victim in a relationship that's likely to continue? That could be a partnership, that could be neighbors, it could be coworkers, it could be a parent-child, but are these people likely to continue interacting in life? And so these are just some ideas of questions when you're starting to develop for your own program, how to determine which cases are appropriate, just a way to think about that.
Okay, so in part one, we talked about the first ever national study on crime victims' views on safety and justice. But how do crime victims feel about restorative justice specifically? National and international research demonstrates that victim satisfaction with restorative justice processes tends to be extremely high. One of the resources that I'm drawing from is the United Nations handbook that is referenced in the resources in your workbook on the last page, including a well-respected restorative justice researcher named Mark Humbright. Closer to home in Colorado, the Restorative Justice Council has spent more than 5 years collecting data on the juvenile diversion RJ pilot programs from Alamosa, Boulder, and Weld. Crime victims in those studies overwhelmingly indicated their satisfaction with the RJ experience. Turning to one of the questions we got after day one was about serious crimes. And I just wanted to note that perhaps surprisingly, participant outcomes are even better with more serious cases. The University of Denver is currently conducting a research study in partnership with COVA and state agencies about high impact victim offender dialogues across the state. And the preliminary data reflects greater victim satisfaction, victim appreciation for using RJ in violent crimes. So research also indicates better outcomes if crime victims participate in the RJ process. That's better outcomes for both the person who was harmed and the person who caused harm. Crime victims have an opportunity for healing, and all of the other things listed on page 3 of the workbook in the Venn diagram for the person who was harmed. And then the person who is responsible for causing harm can learn about the impact they had on the crime victim, as well as other people and the community, which develops empathy and remorse and a whole bunch of other indices that are supportive of reducing recidivism. So the same Colorado Restorative Justice study with the diversion pilot programs that study demonstrated that there was a nearly 5% decrease in recidivism for kids who participated in restorative justice as part of diversion, as compared to kids who participated in diversion where there was no restorative justice component. Importantly, the recidivism rate dropped even further when crime victims participated in the restorative justice process. So If restorative justice receives high marks from both people who have been harmed as well as people who have caused harm, if it offers healing benefits to all, if it is proven to reduce recidivism, and recidivism drops even further when victims, crime victims, participate in the process, then how do we get crime victims to voluntarily, that's an important word, engage in restorative justice? So I would submit that the first way we do that is by cultivating engagement. We need to cultivate this engagement from the harmed people, right? And honoring at the same time that we need to meet them wherever they're at in their healing process. So the first piece of this is drawn from victim advocacy, and we offer the person harmed information, voice, space, and choice. We raise awareness of the possibility of restorative justice soon after victimization. All victims should be told about restorative justice at some point. And in fact, in Colorado, by law, under the Victims' Rights Act, prosecutors are required to tell a crime victim about the possibility, the availability of restorative justice. And if you're looking for that statutory citation, check out page 16 in the workbook. Another way to encourage, another way to give people who have been harmed information, voice, space, and choice is to offer a variety of options for crime victims to participate at a level that feels good to them. We talked a little bit about this in part 1, but options like using or even choosing a surrogate or using a victim impact statement if a crime victim does not feel comfortable meeting face-to-face in dialogue with the person who harmed them. We also need to empower victims in the RJ process itself. Power was taken away from the harmed person when the crime occurred. So let's create space for that harmed person to take back that power through choices like where the RJ process is held, how people are seated, who speaks first. All of these are little things that can really make the crime victim's experience much better. And then finally, we also need to offer space, and that is time for the harmed person once they have learned about restorative justice to process what they have learned and to determine on their own timeline whether or not this is a good option for them and how much they want to be involved, if at all. And they need to be able to do that without any perceived threat of coercion or threats. To do that, we offer restorative justice at as many points along the criminal system continuum as possible, with diversion being only one of those points. Another piece of meeting crime victims where they are at is creating space for restorative justice referrals directly from the person who is harmed to the RJ program without involvement from the criminal system. And that's in an effort to honor that 50% plus of crime victims who prefer not to engage the criminal system whatsoever. We can also encourage victim engagement by increasing public awareness and education around restorative justice so that people know to ask for it if they are ever harmed. And then finally, we need to remove barriers to participation in restorative justice for both crime victims and the people who have caused harm. And this one I drew out of, again, that United Nations handbook. It was just really interesting to read about how we need to decrease the barriers to access for defendants to access restorative justice in order to make it better for crime victims. So we'll turn to that now. So how do we remove those barriers to restorative justice participation? First, I would submit we cultivate open and honest dialogue. Of the barriers to participation, 2 have legal implications based on the way that we have designed our criminal legal system. We discussed these legal concepts in part 1 of the training, but to be very explicit, the first barrier with legal implications is voluntariness. As we discussed in part 1, no one should ever be forced to participate in a restorative justice process. To do so would conflict with a foundational restorative principle. In reality, neither a defendant nor a crime victim really has an opportunity to opt out of the criminal legal system, which is often primarily driven by government actors. But both crime victims and people responsible for harm can and should be empowered to choose whether or not they want to participate in an RJ process. The second barrier to participation that has legal implications is confidentiality. Like voluntariness, confidentiality is a fundamental restorative principle. Confidentiality and integrating restorative justice into the legal system is multifaceted. And first, you got legal confidentiality, which could apply to the current prosecution, a future prosecution, or even possible other legal proceedings, such as immigration or a civil lawsuit. Then the next piece of confidentiality is programmatic confidentiality, which essentially usually looks like an agreement between the RJ process participants, as well as the facilitators. To be absolutely clear, there is no way to enforce those confidentiality agreements, the programmatic ones, if someone leaves a circle or leaves a restorative process and then talks about what happened in the community. That being said, I think it's really critical to be in alignment with restorative principles to encourage as much confidentiality as possible from the participants. One other thing I'd like to just throw in is I like to think about confidentiality like this, and that is that prosecutors should be able to prove up their case without using statements that may be elicited during the RJ process. So circling back, we're trying to create a safe space to cultivate open and honest dialogue to optimize healing and transformation. Another way to encourage participation in restorative justice is by cultivating accountability. From my own experiences with restorative justice as a facilitator and in policy, as well as experiences I've read about from literature around restorative justice and transformative justice, before accountability and personal responsibility are possible, people often have to get past toxic shame. So I'm going to differentiate between shame and guilt for a moment. So shame is that I am a bad person, and guilt is I did a bad thing. Likewise, to juxtapose between toxic shame and healthy shame is often a really good motivator for changed behavior, while toxic shame leads many people to repeat behaviors that they themselves oppose. The person internalizes the shame so much that they believe they're a terrible human, and that they are then not going to be able to show up as their best self. And this ties back into part 1 of the training, where we talked about hurting people. As a quick side note, using labels is one way that criminal system actors, including myself, often perpetuate toxic shame. We use labels like criminal to describe someone who we don't want to actually be having criminal behaviors. So we may actually be like cementing in that person's head that they're a bad person by using that language. Similarly, language around crime victims can be tricky as well. Someone who is harmed may want to be acknowledged as someone who has been a victim of crime and prefer that language around crime victim. But other people may prefer the label survivor to signify that they refuse to let that harm define their life or their identity. So I just encourage us to consider using people first language, especially when we're working in restorative justice programming. So for example, I use responsible person, or the person who's responsible for causing harm, or the harmed person, or the person who was harmed. It's a little bit clunky, but it gives some more humanity to what we're talking about. And then finally, if you're interested in more on shame, check out the work of researcher and author Brown. She has some incredible TED Talks about shame and how we can work with shame and move towards accountability better. Okay, so next up, we've got some best practices. And let me be clear, Chris and I, during our work, have interviewed a ton of programs in the state of Colorado as well as nationally. And these are our ideas about what makes programs, what makes programs work best, how to best integrate it, and how to best support crime victims. So just take away from this, these are our ideas, and these are constantly evolving and changing, but this is a good starting point. So first up, we have crime victims, or the person who was harmed. So these are some ways to support crime victims and survivors throughout the restorative justice process. A few of them I've already discussed today, and so I'll move through those ones quickly, but I just wanted to have them all on one list so you could see them very visually. So the first is to treat crime victims with dignity and respect. And this includes ongoing communication with the crime victim about what's going on throughout the process. Information, voice, space, and choice, like we already talked about. Offering restorative justice whenever possible. Same, we already talked about that. The next one is proper preparation for that face-to-face meeting, if that's going to happen, if that's the RJ process that's appropriate for this case. In my view, pre-conferencing is an absolute must. We want to make sure that the person harmed feels ready. That is, that they understand what the RJ process is, what it looks like, how it's going to go, that they have emotionally processed to some extent what has happened and are able to identify their needs. And then that they also feel prepared and ready for the conference or dialogue or other restorative process. It is also important for RJ facilitators and programs, and I would also say criminal system, to be super flexible with people who have been harmed and offer as many opportunities as necessary for preparation as that crime victim needs or desires. This is especially true with people who have a trauma history, but it's also true just simply if a victim needs more time. We need to honor that as best as we can, given the time constraints that we have in the criminal legal system. So next up, I have centering restorative justice within the centering restorative justice based on the victim's needs. Each crime victim will have unique needs. Each crime victim will have a unique healing process, and it's not linear. It can jump from one point to another point, back and forth, all the points in between in one single day, over a week, who knows? Every person is different, and we need to recognize that how we may expect a crime victim to show up is not actually how this person is going to show up because of their trauma history or whatever that may be. So I think this is really interesting, though. One commonality that research has indicated is that crime victims often want to, or excuse me, let me start over. One commonality is crime victims almost always want to know that what happened to them will never happen again. And I think restorative justice dialogue is a really important way to ensure that with the person who caused harm, it's understanding what the impact of their actions or behavior was. And finally, we want to empower victims in the RJ process itself. And I talked a little bit about that earlier in terms of the choices that they're given to take some of that power back.
All right, so now we're going to talk about some best practices from within the criminal legal system. This is a reminder from day one, guarding against net widening, only sending cases to restorative justice if the district attorney intends to prosecute. If the case would otherwise be dismissed, it should not be sent to RJ. The second, avoiding mixing restorative and retributive values. So when we're talking about integrating restorative justice into diversion, there's sort of two main ways that it could happen. It could be the diversionary practice, so meaning they go through restorative justice and then the case is dismissed, and that is the entirety of what the person needs to do. The other way is that it could be an aspect or a part of a larger diversionary program. And there are many programs who have that model and do it very well. But we do want to just sort of caution that there could be some mixing of both restorative and retributive values when you have restorative justice as a component of a greater diversion program. And so one of the things we would suggest, if that is the model that you're using, is asking before you're adding it, before there are additional requirements, is what is the intention behind this additional requirement? For example, let's say you had a restorative justice process and you were also adding community service. You'd want to ask yourself, am I adding this community service because the person was not engaged or they're showing up late? In that case, it would be more of a punitive or retributive system versus I'm adding community service because it's something that the victim wants or would help restore or repair that harm, more of a restorative framework. So you just want to be careful with the mixing of those two systems in terms of confusing the defendants and just having systems that are not complementary with one another. Another thing you want to just be aware of is making sure that you're not overloading the defendant with things to do to complete the diversionary program if they have a restorative justice contract in addition to diversionary items to complete, and then also making sure that you've thought through what you're going to do if they've successfully completed restorative justice, but maybe not successfully completed diversion, how you're going to handle that situation. Another best practice is to make sure that there's equitable access to restorative justice for all people. So making sure that your program is being offered equally to people of all races and genders, sexual orientation, ages, unless it's a juvenile specific program or something like that. If you notice that the demographics are skewing towards more white people, and that's not consistent with the people who are coming through your system and your demographic or your jurisdiction, you want to look, or you want to make sure that the DA or whoever's making those referrals is aware of this and that you stop and take some corrective action to make sure that the program is equitable. Another very common question that came up is how do we know how much information to share between the restorative justice process and the DA's office? And we would recommend limited information sharing. When we're talking about information, we're referring both to statements that a defendant might make during the process, items on a restorative justice agreement, or information about compliance or how the person is doing in the program. It's very important to establish clear policies to protect the integrity of the process, particularly around confidentiality. You want to make sure that a defendant's able to talk freely and not have a fear that what they're saying during the process is going to be used against them. One thing that we would suggest when you're trying to figure out how much information to share is asking, why is it that the DA wants this information? What is really behind the desire for this information? Is it a lack of understanding about restorative justice and your program? Are they checking up to make sure you're doing things okay? Are they wary of a particular defendant and their success? And once you can figure out sort of what their underlying need is, you can figure out a way that you can share information in a way that both gets at what they need and also protects your program and your process. One example of this is, like, for example, if they wanted information on what sorts of things clients are doing to complete restorative justice. Instead of sharing a particular contract with the DA's office, what you could do is, every month or so, you can share, these are examples of contract items so that they can have an idea of the sorts of things that people are doing without knowing specific contracts. So just trying to figure out sort of the needs of the DA's office. I think it can help. You can find ways that both parties you can still protect the process, be confidential, but also be sharing the information that's necessary. Finally, collecting data, assessing, and adjusting. So depending on your model, either the DA's office or the program will be collecting that data. And we would just encourage you to collect as much information and data as you can, using evaluations before people start the process and after, so you can measure any changes, making sure that you're actually analyzing the evaluations and the data that you collect so that you can use that information to better your program. Really listening and talking to the people who are stakeholders in your program. So having meetings with district attorneys and victim advocates, having meetings with facilitators and community members, as well as the people who are running the program side. All these people are participating or touching the program at different aspects and in different ways. And you really want to be assessing what their experience is and hearing their feedback. We'll talk about buy-in in a minute, but the more that people feel heard and the more that people feel invested, that their voice is being included in the development of your program, the more they're going to be bought into it. So you want to make sure you're really talking to people, you're hearing their experience, and then you're being flexible and you're adjusting. If something's not working, especially if it's a newer program, don't be afraid to stop and, we need to change this here, we need to move this so it can better serve the people who are participating as well as the people who are running the program. From the program side, in terms of best practices, obviously making sure you're treating all participants with dignity and respect, open communication, listening. If your model uses the community group conference model or a similar conferencing model and you're using facilitation, we want to recommend always using co-facilitators, so at least 2 people. Really ensures that you stay true to the fidelity of the program, fidelity of the restorative justice, and also guards against any kind of bias that an individual facilitator may have. It also just helps you connect. Everyone connects differently with different people. You have multiple facilitators, better chance that you're connecting with all the participants in the circle. Diversity of participants. We talked on the system side about equity and making sure that the program is equitable to everyone who's coming into the system. Well, you also want to make sure that once those people are in your program, that they're seeing a diversity of people who are volunteering as or working as facilitators and community members, so that they see themselves reflected back in the people who are running the restorative justice process. Length of restorative justice process. This was another question that we got a lot of. And it's unfortunately another one that there's not just sort of a set answer on. What we would encourage though is that restorative justice hopefully is not a long process. Someone's coming into the system, they're going through a restorative process, and then they're hopefully exiting. And our goal is to have that, really under 6 months. There's always going to be exceptions, cases where there's a lot of restitution and it needs to be extended, or a particularly complicated case that maybe has multiple pre-conferences or something like that. And that's definitely fine. But the rule rather than the exception is we want these to be sort of shorter interventions where we're hopefully, dealing with the harm and repairing that, and then having people move on and move out of the system. And finally, if your program is one that uses restorative agreements, making sure that they're consensus-based so that everyone's having a say in what ends up on those agreements, and then they're also SMART, specific, measurable, attainable, related, and timely, so that you know what it is they're being asked to do and that you have a clear way to measure that. Now we're going to shift and start talking a little bit about buy-in, which is our last topic before we move to our panel. So first thing, talking about buy-in with prosecutors. The thing with prosecutors that I would really recommend is trying to create culture change. And that's an easy and hard thing to do. It's something that can take a lot of time. However, I've seen it happen in the year that my program's been around. Really, I think if prosecutors are able to learn about restorative justice, to see the effectiveness of it, if you share testimonials with them, if you share success stories, and you help them to really see the benefit that it offers to victims, that it offers to defendants, and that it offers really to them as well, I think slowly but surely you will see people really come around. One of the things that I think helps with this is giving the DA's choice over case referrals. And that's a thing that not everyone may agree with, but one of the things that I've seen with that is that it really helps, it really makes the DAs have to buy into the process in order to determine which cases they're referring. So if you have it where, you're telling the DAs which case, or there's a certain list where they don't have any say, they have less ownership over their cases, they have less sort of motivation to get bought into the program. Whereas instead, if you approach it sort of as an education and teaching them about just the benefits, slowly they will tend to come around and really see for themselves why it's something that can be beneficial, and I think you'll see an increase in your referrals as well. Also takes patience, it takes time, building relationships, building credibility. You may have some DAs that get bought in way earlier than others, and that's totally normal. Another thing, anyone who's had sort of experience in a DA's office or around a DA's office, there's often there's often turnover, and there's people who are moving up and promoted out of a certain division. So if you work within a certain division in the DA's office, you want to make sure you're offering frequent training so that anytime someone's coming through, they're having an opportunity to learn about your program and how they can utilize it. One of the things also is that when someone first becomes a DA, it usually takes a couple of months before your feet are under you and you can actually start looking at what programs you might be able to use, what alternative programs are out there. So sometimes if they're trained in those first 2 months, it might be too early before they're ready to use the information. So just making sure that, again, those trainings are frequent and there's access. So when the DA is ready, they've got the information. And then finally, opportunities to either observe or be involved in the process. So this is one thing that came up with our DAs is they really wanted to observe the process, and the community agency we work with didn't think that was a good idea. And so what we did is we created a community member training just for our DAs so that they could be trained as community members and then participate, not in their own cases, in the process so that they could experience it firsthand.
Okay, so quickly turning to creating buy-in or generating buy-in with defense attorneys. One of the most common questions Chris and I get from national programs, not Colorado, but outside of our state, is how do you get defense attorneys on board? That's the big problem for most places. And I would say that that's a pretty simple answer to that. It's confidentiality. Defense attorneys may take very seriously their ethical obligation not to allow their clients to generate more evidence against them. And so we want to make sure this process feels safe in that way to participate. The other piece that defense attorneys will buy in on is we being a defense attorney, I can say, like, I would like it to be supportive for my client. So some attorneys may insist on a beneficial legal outcome in exchange for their client giving up their statutory or constitutional rights. But other attorneys may be satisfied if their client just wants to participate solely to take accountability and to support the person that they harm's healing process. Next up, we have generating buy-in with judges. And while diversion doesn't normally involve a judge, judges can still play a very important role in encouraging the use of restorative justice by identifying appropriate cases and then recommending to both prosecutors and defense attorneys in the courtroom that maybe RJ should be considered. So to encourage judicial buy-in, make sure that the judges, similar to what Chris was already saying about the prosecutors, is make sure the judges have opportunities to become familiar with the RJ program. And then similarly, we need to cultivate judges' awareness of restorative justice success stories. And all of this will lead to lighter dockets, which of course judges will love. So real quickly to sort of summarize this up so we can move on to our panel. We've thrown a ton of information at you in part 1 and part 2 of this training. If you're still eager to know more, up next is our panel discussion with 5 experts in restorative justice program implementation, who will be able to get into more of the nuances that you may be hoping for. But if you are overwhelmed right now with the amount of information we've thrown at you, I've got a little bit of good news. You likely already have a juvenile diversion program in your jurisdiction, in your community, and adults are very similar to kids. They're not very different, so you already have an amazing foundation to build from. Some points of encouragement: adults are easier actually to deal with in RJ sometimes than kids. There aren't any parents. You don't need age-specific language to explain things to kids or for facilitators to navigate. One important difference that I just want to note real quick is that the Children's Code offers broad confidentiality protections for juveniles participating in restorative justice, and the same is not true for adults. And so that's why we've talked so much about confidentiality throughout this. Okay, so next up is our panel of 5 experts in restorative justice implementation within the criminal legal system. Our intent was to offer a diversity of views with programs located both in urban and rural jurisdictions. So I'm going to let each of the panelists introduce themselves, but while they get their screen situated, what I'd like for you all to do is also get your screen situated. I hope this will make for a better viewing, audience viewing opportunity, but We're going to ask everyone who is not one of the panelists to turn off their video and make sure they're muted, and then hopefully just the panelists' videos will appear on your screen. And also, I just want to mention workbook page 14. There's a chart in there that you can use to sort of document your notes around the panelists. Okay, so let's see. Awesome. I'm looking at my other computer here to see I have all 5. So James and I can't read the other name on that. Would you mind hiding your video? Then I think we'd have. Awesome. Thank you so much. I really appreciate that. Okay, so we got 1, 2, 3, 4, 5. Hopefully you see Chris and Liz, Aaron Cordell, Kirsta Britton, Sarah Erickson, and Luke Yoder. And I am going to turn it over to each of them one by one to introduce themselves and introduce their diversion program, describing the model that they use, some of their challenges and limitations they've experienced, some of the benefits they've experienced, and how they have cultivated buy-in from the community as well as the system actors. So I'm going to turn it over first to Kirsta Britton. You're on.
Thank you. So I'm Kirsta Britton. I'm the Director of Diversion in Wells. We have an adult program and a juvenile program. We were one of the pilot sites for the juvenile diversion program, RJ pilots that started in 2013. And that's when we started doing RJ within diversion in our district. We had always kind of done it off and on when we had someone that could do it. It was pretty informal, but we loved it and it always worked really great. And we were excited to be able to formalize something once we had that opportunity with that RJ pilot program. Now, how that came to be, we were one of the pilot sites that had nothing when this all started. And so we had a stakeholder meeting with pretty much everybody in our juvenile system, because that was a juvenile program specifically. And we said, how are we going to do this? And what we kept coming back to over and over again were that the systems people felt like this should not be a systems program. This should not come from the system. So we kicked around like maybe all the systems people would do it. And, you know, I would facilitate conferences for probation and CYDC would do, you know, some for me and that kind of thing. We said, no, we want this to be a community-based program. And so what we landed on was partnering with a nonprofit that serves our entire district that would be able to do restorative justice for our youth. And so we partnered with this local nonprofit. We created a program within that nonprofit to do restorative justice, and we love it. The limitation, the challenge, is that their bylaws specifically say they can only work with people under the age of 18. Now, I have been a squeaky wheel for several years now, saying I can get you adult diversion clients all day long to go through RJ because we do have an adult diversion program as well. We currently aren't in that place, but that's something that we're certainly hoping for. So my experience is really in the juvenile realm, but it's also in taking an existing diversion program and then implementing restorative justice into that program that already exists. We would love to do it with adults. With juveniles, you know, we really focus on everything that we know that says that we should be working with kids as soon as possible. We want to be responsive to them. We want to, you know, we hate it when it's like, what was that thing that you're talking about? I don't remember. So we want to be really quick in working with kids. And what's happened, the challenge for victims participating in restorative justice is that that's too fast for them. And so Liz spoke about that a little bit. It's just too quick. They're not quite ready and they're not there yet. And so sometimes we have to pump the brakes a little bit. And so that does create some challenges. I think our adult programs tend to run a little bit slower just by the nature of the beast. And so we don't have that quite as much. Our programs, we will take a case at any point in the system. So we will take it pre-file, post-file. I've had adult cases come to me. The attorney says, this is set for trial, but will you look at it? Absolutely. So we will take cases at any point in the system, and that means our victims are in different places too. And so when you're looking at that, that's a consideration. You know, it's a different situation when we've had to wait a little bit on a case where we've had to gather a lot of maybe medical information for restitution, and the victims have had more time to process some of this stuff by the time that they get to an RJ facilitation. It's a different experience for them. So because of how we came to RJ in this legislation, it really came from the top down. Our elected DA came to me and said, we're going to do this. And so we had that leadership at the top that was really beneficial, saying that we're going to do this. But there are a couple of quick things that I want to say in regards to getting that prosecutorial buy-in. For one is that prosecutors want to make sure that similar cases are being treated similarly. And so one thing that we do in diversion is make sure that we know that things that go through RJ are going to have similar outcomes as far as being similar, as far as what the things that kids need to do. Now, as Liz said, the success and the satisfaction are different, but it kind of appears on the surface that we're not giving special or differential treatment. The other thing that really helped, similar to what Chris said, is that we do a Restore program, and we have a panel of professionals that speak on that panel, and we've had DAs participate in that. And that's really turned their eyes around too, as far as that buy-in for RJ. So those are some quick things, and I'll be back later with some more to talk at you at. I think Erin's next.
Do I go ahead and go, Liz? Yeah, okay. I wasn't sure if you were going to say anything. Sorry. Hi, everybody. I'm Erin Cordell. I am in the 20th in Boulder County DA's office. I help run our restorative justice and diversion programs. I'm also a deputy DA. We're also one of the pilot sites, along with Kirsta and Luke. We have a diversion program for adults and juveniles. It operates pre-file and post-file. And we have our own in-house restorative justice program that we created about 4 years ago. So we have dedicated staff and a team of volunteer facilitators that serve that restorative justice program. And we partner at the same time with a lot of community-based restorative justice providers. So we're doing a little bit of both. We have our own in-house RJ program. Oops, things are moving around on my Zoom. Sorry, I want to be able to see folks. We have our own in-house program, and then we also refer cases out to community-based restorative justice providers. Right now, we divert about 650, 700 cases a year, adults and juveniles, about 92% success rate, successful dismissal. Cases range from petty offenses up to F3s. We started with a district court juvenile diversion program that we had for years and years and years, and then with the pilot program, we expanded and really started looking at how we can implement more restorative justice. And in the past 5 years, we've expanded step by step. So we expanded to adult diversion, we expanded to county court, we expanded to diverting more drug cases, higher risk cases. And our program model is based on kind of two arms. We have one part of our program that is really focusing on reducing risk of reoffense, reducing criminogenic risk, and meeting needs like making referrals for therapies, that kind of thing, that are assessment based, so that folks can move forward and not do the same thing again. And then we have the other side of our model that's focusing more on repair of harm. And participation in restorative justice is one of the ways that repair of harm can happen, but it's voluntary. So there are lots of other ways that folks can repair harm if for some reason participating in a restorative justice process isn't a good fit. We have been doing around 150 RJ conferences per year. We do specialized processes for drug cases. We have victim offender dialogues and community group conferences for higher harm cases. But if they're not going to participate in an RJ process, we also do other things like lower level restorative conversations to talk with a person about accountability and impact and repair, and then they'll work with their diversion coordinator to come up with a plan for repair. So the benefits for us that we've seen of having the two arms of the model is that we keep those referrals assessment based, so things for like treatment interventions, therapy, that kind of thing. So we're making sure that we're really matching services to needs. Our diversion coordinators are really able to help support the process of getting the person ready for participation in restorative justice, helping support them around accountability. So if somebody comes into the program initially and they're not quite there yet, but there's potential, we can work with them, and then they may be able to participate in RJ down the line. And it has freed up the RJ process since we're able to address a lot of the defendant's needs through diversion. It frees up the RJ process to really focus on repair of harm. So when we get to the RJ process and the victim says, I want to see what you're doing to make things better, and that you're not going to do this again, the diversion coordinator may be there and can say, they're participating in therapy, and the diversion participant can say, here's what I've already done. And then it can really focus on other types of repair. And then it doesn't, since RJ isn't a requirement, we don't have to return the case to court if the person doesn't participate in RJ. We've got other options for repair, so that's worked out really well. Challenges, I heard several of them mentioned already. I mean, staff and volunteer turnover are always a challenge, keeping people trained up, making sure people know what we're doing and what our outcomes are and that it works. Not widening the net is something that you all talked about earlier. The countywide consistency for RJ, like trying to make sure that it's equitable and accessible across the board, because we work with a lot of municipalities in our county. Some of them have their own programs and their own options for diversion and restorative justice. So trying to make sure that we've got equal access for folks. And as far as buy-in, Liz mentioned, Chris, I think that was you, mentioned several different ways to do that. We do a lot of the same things. So we try to make it as easy on DAs as possible to send us a case, right? So we're going to do the work. We're going to file the motions to dismiss. We're going to take care of all of that stuff. Finding a couple of champions in your office. So, if it's you're elected, that's great. If you've got a couple of DAs in your office who are kind of interested in it, you can maybe start with them, make sure that they see the process and know what you're doing, and then can spread the word to others. Sharing specific stories, having like a couple of stories under your belt that you can say, like, this happened, and just being able to just rattle it off. Quotes from people, from victims, measuring outcomes, like in our satisfaction surveys for participants that we give, we're really thoughtful about what we put on those. Like, has this improved your impression of the criminal justice system? Asking questions like that, and then people love to hear that, oh wow, defendants feel better about the criminal justice system, that's great. Those sorts of things have all been really helpful. And then just having great outcomes, low recidivism rates, happy participants.
Okay, assuming that Aaron's done, my name is Luke, and I'm the director of the Center for Restorative Programs. We're located in the 12th and serve the 6 counties of this judicial district through a community-based organization called Center for Restorative Programs. And I guess as far as kind of our origin story, we started a long time ago, 25 years ago, as a response to what people in the community saw as the overcriminalization of typical youth behaviors, and often disproportionately impacting Hispanic youth, and that's the largest minority population in our community. And so as a result, we started doing restorative justice-based juvenile diversion, and that really was the arena in which we operated for many years. And as a result of that work over time, like people have mentioned, as we experienced successes, as people saw us and what we were doing as more credible, which in large part is also due to the fact that we were a pilot site starting in 2013, along with my colleagues here. That really helped to build credibility. But over the course of that initial 20 years of our operating, again, people saw the impact. They saw victim satisfaction that people have talked about. They saw offender outcomes that people have talked about. They saw more meaningful repair and reintegration back into the community. And to use the shame language that Liz was talking about earlier, saw people that were reintegrated and used reintegrative shaming in a really positive light, in a positive way, instead of more stigmatizing shaming that Liz talked about. And so people were starting to see those outcomes, and as a result have asked us to also work with adult diversion. And big kudos to my partners who are also on the line here today in the DA's office, Bliss and Megan, for really driving that adult diversion opportunity from the DA's office perspective and really making that an option as well. So we're now working across both juvenile and adult populations. And similar to what Aaron said, we offer similar programming in terms of having victim offender dialogue that's available for direct conversation between victims and offenders. And again, using people-centric language between harmed parties and people responsible for creating harm. And we also do some processes that are specific to substance use called rethinking substances. And further, we do some community-based conferencing for those higher impact situations, very similar to what Aaron mentioned. So those are some of the processes we use. Similar to Kirsta as well, I love that there's so many similarities between what we're doing because I think it shows some of the common threads that are really helpful and important. One of those is that as we started to really deepen the work that we were doing here in the community, again, as partly as a result of the 2013 legislation naming us as a pilot to do restorative justice diversion work with juveniles, we did also convene a stakeholder group of all of our juvenile justice system partners, and that involved the DA's office. And one of the differences anyways, between my colleagues on the call and myself is that we are an outside community-based organization that I would purport is the kind of main driver of diversion, or has been the main driver of diversion and restorative justice-based work in our community. And in part, that's because our DA's office has so much turnover and there's so much flux in philosophy as electeds come and go. And so at that time, we had an elected that really was not convinced that restorative justice was the right way to go. And so as a result, we had to work as community partners to really sit down and figure out what were the right ways to get as many kids as possible so that everyone had equal opportunity throughout our huge geographic expanse. We had to figure out how to try to do this in somewhat of a piecemeal way. So while we do partner now really closely with our DA's office because we have an elected and we have their staff who are really supportive of this work, we also had to create lots of other workarounds. So we take a lot of direct referrals from police departments. We take a lot of direct referrals from municipal courts, which again creates a bit of a patchwork of ways that juveniles and adults can enter into a restorative encounter. But it really is something that has proven very successful and probably the best outcome that we can have in our community because it doesn't rely solely on one referral partner that again can really shift and change over time as philosophies shift and change, as personnel shift and change. And so that's part of how we've structured ourselves that again is a differentiator perhaps from how things are functioning in our other JDs. So I'm going to stop. We can get to other things. I'll turn it over to Sarah.
Thank you. Sarah Erickson. I'm with the District Attorney's Office in the 18th. I am the Director of Diversion. I have to say, the tree outside this window here, as it's lost all of its leaves, it now lets in a bunch of light and I can't figure out where to put myself to be able to, I'm worried that I'm just a white blob and you can't see my face. So hopefully the sun will shift and you'll be able to see. But so I'm a district attorney in the 18th. I'm also the director of diversion. We have both adult and juvenile diversion. Both of our diversion programs are post-filing pre-adjudication. We historically had been a pre-file diversion program. There were lots of reasons why we switched. That's a different conversation, I think. But in our diversion program, we had been dabbling in restorative justice for a long time, case by case. And there were just a couple of people on our team who were really invested in the process. And so they brought, what they could into our program. And then we made a switch, it was about 4 years ago, where we made restorative justice a mandatory condition of our diversion program. And the reason that we did that was because we were starting to get a lot of questions or concerns and some criticism that because of the nature of our diversion program, kids primarily were not actually addressing the behaviors that got them into diversion in a direct way. And what I mean by that is that our program is a counseling program. We, when fully staffed, we're a team of 20. 2 of those are victim advocates, and then there's me and a support person, and everybody else is a therapist. So what our program has been traditionally is focused on looking at risks and needs of youth and like what's driving their problematic behaviors. And we focused on addressing those risks or needs. In that, obviously there was conversations about what happened when they got there, but I don't think this will be a surprise to anyone in this group. Oftentimes the behavior that led to a criminal charge or a juvenile delinquency charge, that was more just like a blip, and it wasn't really about the underlying behavior or problems that were there. So there was, we were getting a lot of, I'm going to say, heat in that way. And so we made the shift to say, okay, well, we're going to do this in two ways. We're going to have everybody in diversion participate in some form of restorative justice so that we can make sure that we're saying to our community and specifically to our victims that we are addressing head on the behavior that landed them in our program. But we are still going to do that piece looking at risks and needs and making sure that we're making people, I like to say we're putting them in a better position so that when they leave our program, they're less likely to return not only to the criminal system, but to any system. So we still sort of have these two rails that we roll on, which raises the question about voluntariness with restorative justice in our program. Our entire program is voluntary. And again, I say that with the asterisk knowing that, as Liz pointed out, when people are involved in the criminal justice system, very little feels voluntary. But when, if you choose to participate in our diversion program, you are also choosing to participate in restorative justice. And so that becomes a piece that everybody participates in. We keep a really broad menu of what restorative justice looks like. We use groups, we use circles, we use conversations, and then we also use a one-on-one process that people do with their therapist, just to make sure that we're using as many means as we can to make sure that the principles of restorative justice are sort of given life in every one of our diversion cases. That time goes really quick. I think my time is up.
All right. Thanks, Sarah. And I'll try to be quick because you all have already heard a bunch from me, but I'm Chris Brown-Haugen. I run the Restorative Justice Program at the Denver DA's office. We do also have an adult diversion and juvenile program, but they are not connected to the program that I run. We started our program a year ago, so it's pretty new, and it's just for adults. So it's a little bit different than some of the other models that you've heard about. So ours is really akin more to a deferred prosecution model. So they're post-file cases. In our program, the district attorneys have gatekeeping power. So that's why I was talking a lot about culture change, because that's been a really main part of my job since I've been there is trying to work on culture change within the office. So anyone can identify a potential case, defense counsel, victim advocates, or DAs. But the DA has the final say in whether or not it gets referred to restorative justice. Our program began in county court, and we are now expanding to district court, although we do have a capacity issue because of our funding, which we are still working on, which I would say has probably been our greatest challenge, is having a program begin in the age of COVID has made sort of coming up with sustainable funding for a program expansion difficult. So our capacity is capped at 6 cases a month right now. So at this point, we've done about 60 cases through the program. The program is a partnership between the DA's office and the community nonprofit in Denver called the Conflict Center. So I screen the cases within the office once they're identified. The defense counsel is able to sit in on those screenings, which has helped, I think, with a lot of the buy-in from defense counsel, as well as probably the most important thing is we do have a confidentiality proclamation that our elected DA signed, just ensuring that nothing is ever used against them. So I think that and the defense counsel's ability to sit in on the screenings has really helped with their buy-in and understanding of the process. The case then gets referred to the Conflict Center. We use pretty much exclusively a community group conference model at this point. In talking about expanding to broader cases, I think there is some discussion and maybe doing some either thematic or victim offender type dialogue cases in the future. But right now we pretty much just do community group conference model. Once a person completes the program, they send notice back to our office, and then we file to dismiss the case and move to seal. So again, they are filed cases. They remain active in court while someone goes through the program. So there's no sort of dismissal that happens. We do make sure if someone is set for trial, they withdraw any not guilty plea. So we will, similar to Kirsten's program, take a case sort of at any stage. But if it is set for trial and they're going to go through restorative justice, we'll have them withdraw that plea while they go through. And I think those are the main things. So we'll move on to sort of the questions so we can hear from some more people.
So sorry, guys, we were going to try to do this with 2 screens and it just didn't quite work out as we had hoped. So Chris and I are just going to float back and forth on this one screen. So we're now going to turn to the panel section where I'm going to offer some of the questions that you all asked in the registration, as well as other questions that the group of panelists decided would be really important for you all to hear some nuances around. So the first question is about how each of your programs identify RJ appropriate cases, what types of cases go to restorative justice, and how long does the RJ process ideally last? And I will open this question up to any of you who would like to speak to that at this point. Okay.
So since we're all jumping in at once, I'm going to start. So I think just to respond briefly to that question, I think that one of the big things as far as appropriateness is that, again, there's a buy-in factor. And so like a couple folks mentioned, I think Aaron, you said that you guys take everything from petty offenses up to F3s. I think that's very similar in our jurisdiction writ large. And I think that part of the reality for us is that we take referrals from many different sources, and each one of them has a slightly different threshold for what they'll consider. And so to go to something that Chris said earlier, a lot of it has to do with, you know, those gatekeeping agencies and what their level of comfort is. And typically, in our experience anyways, when we work with a referral partner, whether it's law enforcement, whether it's municipal court, whether it's district or county court, whether it's our DA's office, the threshold typically starts pretty low. They don't want to, or high maybe, they don't want to refer a lot of cases because there's a lot of skepticism, there's a lot of uncertainty, there's not a long track record. They maybe have heard a story or two, but they haven't seen it work. And so as we go throughout doing the work and we experience the successes that we all know come along with doing these restorative justice processes well, then we often will see people start to lower the barrier of referral and start to refer more frequently. So that's been our experience locally.
I think Erin had a great answer when she said anywhere there's been harm. And some of the cases that we've seen, and this is in the juvenile world, not in the adult world, but some of the cases where we've seen some really powerful stuff is when maybe it's a drug case or a shoplifting case where we don't have a named victim present, but they are repairing the harm within, you know, there's harm that my mom got a call from the police officer and she had to leave work to come get me and that kind of thing. So, you know, any case where there is harm caused, and sometimes we have to think outside the box as far as what that means, what harm means. We do a presentation for students as far as the role of the prosecution, and we say, if you were to write out your definition of justice, let's say that there's 20 of us on this call, we would have 20 different definitions of justice written out. And so it's the same thing when we're thinking about harm. We would all have a different definition of what that means. And so when some of us are probably more the shades of gray thinkers, and when we're dealing with our law enforcement and our prosecutors, we're dealing with our more black and white thinkers. And so how can we reassure them, this thing happened, and this is how I think that we could respond to this, because there was harm that was caused that we can address through RJ. And so some of that is relationship building with our, within our own offices or within our own systems, so that we can have those conversations and we can talk about, this is what harm is. It's not necessarily always what the charge is that's listed.
I'll say for our program, because one of the things that is a limitation is that we do have to have the victims open to restorative justice. Now, that does not mean they have to participate, but if a victim for whatever reason says, I don't want restorative justice, our office won't refer it. And that was a huge point when we were developing the program, but really just being housed in a DA's office, there was no way to get the office behind the program without that. So that's been an interesting piece. along with the DAs having gatekeeping powers. So when we started, we did primarily all sort of criminal mischief, theft, low-level cases. And then 6 months later, we were seeing a lot of third-degree assault and child abuse. And I would say our main types of cases are child abuse, third-degree assault, and probably still some theft or careless causing injury. So it's been really interesting to sort of see that development of cases kind of get to more serious cases. And we're, again, all adult cases and all misdemeanors right now, but we are now moving into felonies, and it's a whole new group of DAs. So it'll be sort of, I think, the same thing again, where you start at the beginning with those low-level cases and you build relationships and buy-in, and then you get to move to more serious cases.
I think the only thing I'd quickly add, I'd echo everything that you all said. I think it's largely, we're looking at the level of harm and the needs of the parties, right? In general, we don't typically do a restorative justice process for a low level like merchant theft, just because of the amount of resources and time and everything required. A lot of times that could feel, it can feel like overkill to somebody. They stole a $3 keychain, and then there's 20 people sitting around a circle to talk about it. So we're really looking at our capacity too. So in general, like a first-time MIP, we have different sorts of interventions. A first-time merchant theft, that kind of thing, we're not necessarily going to do a restorative justice conference. We're going to do like a lower level intervention, like a conversation and things like that, unless there's a specific need from the parties.
And can I just add really briefly to what Aaron said? I think prompted some things for me too. One is that I think that there's a continuum of restorativeness that we all operate on. There's things that are more fully restorative, that there's lots of parties involved. There's really direct harm that's being repaired. It's very, very victim-centric and victim-driven. Wouldn't happen without the victim participating, et cetera. And then there's also stuff that's further up the continuum that's a little bit restorative. And some of the things that Aaron's talking about, where there's a restorative conversation, that's a great place to start for some of these things, but it might not involve a direct victim. It might not involve specific harm repair because you don't have those other parties involved. And that's true for an MIP offense where there's typically not a direct victim. That's true for a shoplifting offense. And that's why programs like Kirsta's do Restore, which is a panel-based or kind of large group-based intervention for those shoplifting situations, why we do something called Rethinking Substances, which is a larger group circle process where there's 4 or 5 youth or young adults participating in a circle. And so those are pretty restorative, but it's not either or, it's somewhere kind of in the middle. And that's also why we use a lot of surrogate victims, especially for low level offenses. If the victim's like, look, this isn't a big deal, I don't want to use 3 hours of my life to do this, well, then maybe we can have a law enforcement officer come and sit in as a surrogate victim, or we can have someone that's gone through a like situation in the past come and sit in as a surrogate. So I just add those two things, that surrogate victims and then restorative versus fully restorative versus somewhere in the middle.
Awesome, thank you all. Oh,
you had asked about timeline. Sorry, I don't think any of us mentioned timeline. We're looking for adult cases. Most of our cases resolve in 6 months or less for the diversion case. I'm seeing some nodding. For juvenile, for unsupervised cases, like super low level cases, 4 months or less for our program.
Sorry, I'm just weird popping in and out. Thanks, Aaron, for clarifying that. So the next question I have for you all is, how is information shared between the RJ program and the individual prosecutors or the DA's office generally? And then when this, like, that arises for status updates, but it also sort of arises within the context of substance abuse or mental health issues. So I just wanted to pose that for the panel, and I think there are a couple different views on this, so I want to explore those. And I think first, Erin, would you mind talking about what goes on in your program? Sure.
So a lot of what you all mentioned earlier is what we do. So I mean, our RJ program is a subset of our diversion program, and we're in the DA's office, and 2 of our diversion staff are deputy DAs. And so we have information about the case already. And so, but we're really aware of wanting to try to create as much of a firewall as we can to protect participants. And so general information like, are they complying with diversion? you know, we're sharing that, revocation, obviously completion, that kind of stuff. That's all shared in our shared database. So folks have that information. And then we overlap in some certain areas too, around communication with victim witness or restitution. And so there's information sharing that happens there. But details about what's said in the restorative justice process is very, very, very much protected. There's some exceptions. We let people know that we're mandated reporters, obviously. And we do have an exception that we carved out with our DA's office that allowed us to do this at all, that says if we hear about another crime with a victim, that we could disclose that. And that the reason for that is that we want to make sure that we're not leaving that victim without support. Other than that, we're not interested in prosecuting other crimes. We're not interested in prosecuting co-defendants. We do share information, you know, from the RJ like pre-conference with the diversion coordinator. We let people know that so that we can coordinate, you know, preparing for the process, that kind of thing. And then everybody signs a consent form around confidentiality. They say that they're not going to call us to testify. We say we're not going to share information with those exceptions that I mentioned above. We're really wanting to create a space where the person who caused the harm can step up and say what happened and be honest about it, and take meaningful accountability. As far as mental health, things like that, we comply with HIPAA. So if we have a victim who is wanting to know, you know, how's this person doing on diversion, there's certain information we can share, there's certain information we can't, depending on if it's part of a court order, if it's, you know, and it's usually not because we're looking at pretrial. And so we're really careful about that unless we have the defendants express release to share more information. If somebody's in an RJ process, we do give victims the right to see the agreement that comes out of the RJ process, but we let folks know that beforehand. And so if there's something that a defendant doesn't want shared, we're really careful about how we write that. Those are some things that come up for us. Krista, do you want to add more?
You just say, we just shared something for the very first time with the prosecutor, and that was in a juvenile case where the victim objected to expungement, and with the juvenile and their family's permission, we shared the really amazing apology letter that he had written as part of his RJ contract. That was the first time we'd ever shared anything. So it just doesn't come up all that often.
Agreement, so that everyone's really clear on what's going to be shared and to whom.
So ours is a little bit different in the 18th, and that's because we have to follow not only, you know, the rules of the criminal or the juvenile justice system, but because we are using mental health providers as our diversion counselors, if you will, we also have a whole nother set of rules and regulations and best practices that we have to follow around confidentiality. So all of the communication that happens within our program happens under that client provider privilege. So we can't talk about things in diversion unless we have a release. Our program is very contract based. So in our contract up front, we do have some releases built in so that everyone is aware from the beginning when we'll speak to a DA and what information we share, and when we will speak to a victim and what information we'll share. So for us, for the DAs, we will talk to a DA about a case if we're returning it for non-compliance, or if there's been a new case that we're advocating for it to come to diversion, or sometimes it's because there is non-compliance that we know we're supposed to send it back, but we want to advocate to keep. And in those situations, what we can talk about are, you know, why are we having the conversation? We talk about a summary of treatment, which is not to say that we discuss what's being discussed in treatment, but we will say things like they were in therapy. And if there's a safety concern, we'll share a safety concern, or if we have a treatment recommendation, we'll provide a treatment recommendation. And that's when we talk to the DAs. We specifically do not allow the diversion team, not that anybody would want to talk about the accountability statement that we require to participate in our diversion program, and that is always a part of restorative justice. We can't share that information unless we have a signed release by the participant, whether it's a juvenile or an adult. So our confidentiality really is based on privilege that we intentionally establish and then based on releases and waivers that we build into our contract.
One thing I'll throw out there very briefly, sorry, Liz, is just that from an outside community-based perspective, I think it's really important to be very clear up front with your DA partner or other referral partner what will and won't be shared back and forth in terms of contract information, because I think that's really clear. It's important to be clear and on the same page about expectations around that. The other thing is that I think it is really, really important also to set up a protocol for just sharing updates in general. So as an example, our staff send weekly updates to our partners saying, here's the current caseload, here are the folks that we're working with, here's where they're at in their process. So intake has been completed, or they're pending process, or they've mediated some sort of agreement, but we haven't completed it yet, or they've completed successfully. So we just provide that information regularly to make sure, again, that we're all on the same page, we know what's happening, and there's no surprises that come up, particularly as we're talking about, again, wanting to be really intentional and thoughtful about our timeframes, that we aren't letting any referrals get too far out so that our partners feel really comfortable with the status of things. So it's just over communicating and being really clear about what those communication patterns need to be, I think is really important.
Okay, thank you. We're going to move to the next question, which is, what advice do you have for working in rural areas with limited mobility and community partnerships? What advice do you have on types of places to coordinate restorative justice programming besides recovery clinics or family centers? And what about old community drama playing out? And I'm going to focus this question on Luke, Kirsta, and Sarah because their programs all offer programming to rural areas.
Luke, I'll start if you don't mind. I was just going to say that when we talk about restorative justice, and I can say this in front of Aaron, a lot of times people go, oh, well, Boulder, of course, Boulder is going to have restorative justice, right? But then you talk about our rural communities and like, I don't know. When I think about restorative justice in Weld County, I think about like two farmers like leaning on a fence of like a shared property line. And how are they communicating with each other? And how are they resolving conflict? And whatever conflict they have, I don't know, cows getting out of pastures, I don't know what that is. What is that? What does that look like? Because they live together and they work together and they have conflicts and they move on and they deal with it. And so sometimes our language might be different, but it's still happening. So when we're talking about restorative justice and we're getting folks on board, I think that part of that is really looking at like, what is the culture of my community? How are we talking about conflict in my community? Maybe we're not, but things are still getting resolved, or they're not, and Luke can talk about that. And where are those conversations naturally occurring? So like, if you know that everybody is like showing up at McDonald's and drinking coffee in the morning, then like maybe that's a place that you go. And so when we're looking at our communities, we get very much in our system lens. And I think that sometimes it really helps to go, what's already happening in my community and how are people doing this naturally anyways? Because restorative justice is nothing if it's not an organic process. So how can we honor what is already happening, speak that language, and really fit it into our systems that are already in place?
Yeah, and just I would echo all of those things. To jump off of that, I think a couple other considerations from our end are that we cover a huge expanse of geography. And so in the past, one of the things that Chris had mentioned earlier is the importance of making sure that we're responsive to the parties that are involved, particularly to victims. And part of that has to do with where we meet. And so if we have somebody in a far-flung corner of our valley, in the past, we would try to go to them and meet in their context, whether that's meeting in a library, meeting in a public meeting space somewhere, something private, so we can have a private conversation. We would do what was indicated by the parties involved. And so we do a lot of responsive setting of locations. One of the things, this is skipping ahead, I think, to the next question, but one of the things that we've had to do during this time is because we aren't gathering physically, we're doing a lot of our work remotely and we're doing a lot of work over Zoom. And so we've moved almost all of our work into a virtual context. And if you get creative, you can do this well. There are some good tools available now, this being one platform that offers a lot of creative options. So we started to do things remotely. And I believe that even after we've come out of this kind of pandemic reality, we're still going to end up doing a lot of work in this fashion because it eliminates so many transportation barriers, logistical barriers for a lot of folks in our community. So that's one kind of quick response to where things happen. And I think one other thing about the rural community aspect of this is that there are, because like Kirsten mentioned, we live and work together, we're going to see each other. It's a little bit of a hook also, I think, in terms of buy-in getting from different referral partners that, look, these people are going to run into each other. If we do this work now, it's going to prevent a lot of future problems. And our law enforcement officers like to hear that. Our justice system partners like to hear that. There is a lot of generational stuff too that can happen, and we haven't talked necessarily specifically about that as part of the question. So just really briefly, I think that it is really important for us to be aware of what those dynamics are. And a quick aside, one of the very first cases I did when I moved down here 15 years ago was two girls who had this big drama, big fight. They were both ticketed, came to our program. Turned out that there was a lot of family history. Well, my mom didn't like this guy's boyfriend of your aunt, and so now there's drama, and it's generational. I mean, it's 3 or 4 generations back. So we ended up doing a mediation, direct dialogue conversation between the parents, because the girls were fine with each other. They're like, I don't know why, we just know that we don't like each other when we aren't supposed to, as the Hatfields and McCoys. So we sat down with the parents and said, you guys are driving this conflict for your kids. What are you going to do about it? And they were able to kind of work through that and stop being a stumbling block or barrier for their kids. But that is a dynamic that we see a lot of, is long-standing historical drama. And that's the downside, or one of the downsides of a rural community. The upside is that we do have a lot of relationship-based interactions, and people are more willing to sit down with somebody that they know they're going to see again.
I think I would just talk to the question about bringing in community drama. I know that one of the challenges for us when we're doing work in Lincoln and Elbert counties in the 18th is that it's sometimes really hard to keep it focused. We often get cases, if it's coming out of the schools, for example, where everybody knows everybody. And I think we've done enough restorative justice in those communities now that people know that it's going to happen if it comes to diversion, if a case comes to diversion. So, you know, I'll be getting phone calls like from the mayor's wife, who I'm like, what is your connection to the school fight? And it's somebody's brother. I mean, that's the great part of some of those smaller communities, is they really are intertwined and they're connected in that way. But something that we have to be really careful about when we're thinking about restorative justice in terms of like, how are we keeping this focus and thinking about that confidentiality piece, that we're not here to, you know, add more gossip to the fire or to add to guilt or shame or reputations. So we have to be really careful and thoughtful about that, but we also don't want to alienate the community to say like, you're not welcome in this conversation. So there's a lot of navigating that goes on there. And we like to give a lot of control over who's at, let's say, a restorative justice circle to the victim. So they get to sort of weigh in and pick who's going to be there, who's going to be a support, and help us to draw some of those lines. So I think that in a different way for us, at least in some of our rural communities, that benefit of that connectedness can sometimes be a challenge in figuring out how to navigate or to set up the circle or whatever restorative justice process you're using.
So I want to honor that it's 4 o'clock. So for those of you who have to leave, we will send out information about surveys in the CLE, so don't worry about that. But Luke mentioned that we had one other question, which was about coronavirus and how to adapt right now. And so I'll offer that question to the panelists, and any other final thoughts you might have that you have gathered over the time while the others have been speaking.
I don't have a ton to add to what Luke said about doing this virtually, except to say that it's gone a lot better than I thought it would at first. And I'm seeing lots of nods there. I had my doubts about, you know, when we do restorative justice and we're in person and people can see each other and really hear each other, and that's powerful. And what aspect of that is going to be lost if we move that to a virtual environment? What's that going to feel like? Is emotion going to come across? Are people going to be able to read each other? All of that kind of stuff. And it has gone remarkably well and has still been incredibly powerful and meaningful for the people involved. So I'm really excited about that. And I'm excited to have that as an option as we move forward in a post-corona world someday, hopefully, right? And that we can still offer that and have that be an option to increase accessibility for folks.
Yeah, I would just echo very much that I mean, I was somebody that was drawn into it kicking and screaming in terms of the virtual setup. I thought the magic is all about being in the room, and I still believe that to be true. When and if possible, let's get together, because that's where the real connection can happen. And this is our reality right now in this moment. So let's figure out what our tools are. The successes have been incredible. I think, again, there are things that we will continue in perpetuity as we move forward, because it does offer so many options for connection for folks that might not be able to do so physically for whatever reason. So yeah, I think there's a lot of good opportunities. And the last thing that I would say in terms of closing thoughts from where I sit is that as an outside partner, it is critical to work at building relationships with different justice system stakeholders. And each community is going to look different in terms of the right access or entry points for referrals, whether that's, again, direct from law enforcement, whether that's from municipal courts, whether that's from DA's offices. Making sure that you understand what their goals and needs are is really important as you approach them if you're an outside partner. And ideally, again, you've got people who are interested in this work. There's a lot of focus on this around the state. And so people are open to these conversations right now. Just be thoughtful if you're a system partner about how you interface and work with your community partner, and vice versa. Because there's a lot of opportunity for intersection and really meaningful and good work. Let's just engage each other thoughtfully and with intention.
I think I would just say in closing, if you're starting something new and you're intimidated by the paperwork, please reach out. We would all, I think I'm okay saying this to everybody, be willing to share the paperwork, because that can be intimidating. So don't let that be a hurdle to starting something. And the other thing that I would say is that I do think it's really valuable to include representatives from the victim community, whether that's advocates or other victim-based organizations, wherever you are. Include them in the conversation about what it should look like and what it can look like. I think for us, a large part of our success is that we have specific victim advocates within our program that really focus on victim needs. And it also really helps with the buy-in of our district attorneys and law enforcement to know that what we're doing different than the court system is that we're actually giving victims a real voice in what happens in a case, which is not, in my opinion, really true in the criminal justice system. So those would be my two parting thoughts.
I want to speak to a different piece about COVID, and that is all the budget cuts that have kind of hit all of us. And so I would say it's more important than ever to really be collecting your data and getting those surveys, especially with those really, great questions or statements and responses about victim satisfaction, and anything that you can that's going to help down the road as you're looking at funding situations that we're all facing right now. And so really kind of thinking through that lens as far as this can absolutely make such a difference in the system, and how can we kind of protect that as we're looking at budget cuts, but also being in a society where we really need to be able to sit down and have decent conversations with one another.
Just to jump off of that, I'm sorry, this will be the last time I talk, I promise, Liz. I really like the what you added about funding, Kirsta. I think one other thing is that if we get really zero sum about funding, I think we run into a lot of problems and challenges. I think right now we have to be really creative. I think, again, the reality is that as system partners, our DA's offices have access to funding that community-based partners might not, and the reverse is also true. And so the more, again, that we can build really meaningful partnerships together, the more likely we are to be able to find funding and to sustain our work. And so I would just say, again, if we can get off of it has to be my money, it has to flow through my program, I have to control everything. And that's true for community-based programs, and that's true for system-based partners. Let's be thoughtful about this. Let's think about this more globally, and we can come up with really good solutions, I think, as we move forward, even if things are more challenging.
Stop share. Sorry, guys. I thank you so much for the panelists. I'm trying to get back to sharing my screen so that I can finish up with a couple quick announcements. So hold on just a sec. Bear with me, please. Okay. So we don't have time for that. So Chris and I will stay on for questions. Those are our email addresses, and we will also offer you the email addresses from the panelists too. So if you want to reach out to them individually, by all means. And then one last thing, if any of you are wanting to connect with other RJ programs or practitioners, or want to participate in a community of practice around using and integrating restorative justice within the criminal legal system, consider joining Colorado Coalition for RJ Practices, which is a nonprofit membership organization. And we're hoping, if you are interested in a community of practice, that is us meeting regularly to talk about our challenges, our successes, feel free to reach out to either Chris or I, and we'll start generating an email list and work with CCRJP to put that together. Thank you guys so much for attending this event, these 2 days. We're going to send out survey information and CLE information by email like we did last time. And we recorded this, so if you want to check it out, let us know. And thank you so much for everything you guys are doing. We really appreciate your dedication to thinking about things a little bit differently.